Good afternoon, everyone, and welcome. We have a really exciting webinar today. We are really eager to have a conversation about consumer choice in privacy law. I have with me two wonderful guests to chat about this issue with. First, Chris Lyon, a partner at Freshfields, and also is the co-head of their global privacy and security practice. And then I have with me Troy Sauro, Director, Data Protection and Privacy at Google. So welcome to both of you. And the topic that we'll talk about today is consumer choice in privacy. In the United States, and I think even to a decent extent in the EU, the goal of the law is to try to put the consumer in control, put the consumer in the driver's seat, give the consumer information about their privacy through notices, and then give the consumer certain rights to exercise about their privacy, right to access this information, a right to correct it, a right to delete, a right to opt out, or there could be opt-in rights, and various rights. And the big difference between the U.S. and the EU is the extent to which an opt-out approach is relied upon. The EU has a more stringent view of consent, where typically opt-in is the only way that you can get consent, whereas in the United States, under what's called the notice and choice approach, as long as there's a notice, people don't opt out, it's considered that they are okay with whatever uses and practices are done with their information. And this approach, though, in both, the idea is, to give the consumer choices or control. And I think there's some problems with all these approaches. But I think first it'd be great to talk about the notice and choice approach in the United States. Chris and Troy, do you have any thoughts on the notice and choice approach? And what's your perspective on how does that approach work? Is it working well in practice?
Sure, I'm happy to kick off and Troy can add additional comments. I think when we think about notice and choice in the US, sort of question, what do we mean? And often what it's meant at a high level is consumers have the choice, as you're describing, Dan. The company gives them a privacy notice and they decide, do I want to do business with this company or not? And if you don't, you have the choice of taking your business elsewhere. So at a very high level, I think that's traditionally been the thought of notice and choice. It's not necessarily granular choice. It's choice over where you, as a consumer, take your business. But what we've seen over time is more granular choice coming in under laws. The choice to opt out, like you're saying, of different practices, of commercial email under CAN spam, or now under the CCPA to opt out of the sale of information. But I think one of the challenges is that the choices are fairly limited right now, and they all put the burden on the consumer, which is challenging also for businesses, I think, as they're looking at it. Troy, I'd be interested in your thoughts on how you're seeing the notice and choice model evolving.
Yeah, for sure. Thanks, Chris. And I think it's a multifaceted question and issue, as you said at the start of your remarks. Because it really does depend on the user and the service and those expectations. And that's something that we think about at the start and at the heart of the way that we approach this is what would be the most useful information for the user and what's the best way to get it in front of them so that they can make those informed choices. Is it a perfect system? Certainly not. Is it one that lends itself to easy sort of black and white answers? No, but I think that that's important. Fostering innovation and progress and a lot of the technology that companies across the internet provide require some amount of flexibility in making those choices about what would be best for your users and what they would want to decide or choose when they're engaging in that thought process about interacting with your products. And so leaving the room, creating clear standards, obviously, and as consistent approach as possible is important. But it's also important, I think, given the dynamism of technology and products, to leave open that flexibility to sort of set a course that makes the most sense for whoever your users happen to be and whatever it is that you happen to be providing them and doing with the data.
So I want to play the professor a little bit and basically throw out some almost like unanswerable questions. But one challenge that we have with the idea that, we're going to give the consumer these choices, and one issue is, are the choices good enough? But let's say they are. Can the consumer really make these choices in a lot of cases? Can I really make an informed choice? And it's hard to do. Should I have a smart doorbell? Should I use a home assistant device? Should I do a lot of things? Should I share information about I'm going on vacation on Facebook? All of these are things that, I don't know. I mean, maybe not. It kind of depends on, how the data might be used in the future. And also, in what ways could that data be combined with other data? What algorithms might be used on the data, and then what decisions might be made on those algorithms. This is really complicated. And now suddenly, I'm a privacy expert, and I have a tough time figuring out the risk equation. Is this going to hurt me? Is this going to harm me? I don't know. So that's really tricky. And then it doesn't scale. And I think that a lot of companies really try hard to create a system of choices and granular options for people. I mean, Google does, and you have a lot of things you can do. But I liken it to kind of like, professors giving homework. I might give homework, and okay, there's a lot of homework, but it's good for my class. But what if every professor is giving a ton of homework? And instead of having, a few professors, you have 1,000 or more, so every company is saying, hey, look at all our choices, look at all this, and after a while, it's like, I can do it for 1 or 2 websites, but I can't do it for 1,000. So it doesn't scale. So those are some structural problems. The people just can't make a decision because they just don't know enough, and it's really hard to actually make informed decisions. And then there's just too many choices, and it's really hard to make those choices across all the companies that have your data and that are using your data. So how do we get around those problems? Is there some way to move forward beyond that?
Yeah, I mean, this is one of the reasons that we think of things in terms of sort of the broader spectrum of safety and trust and ensuring that users have that, because that is a bedrock of making sure that choices that users are making are informed and they feel like they can make them. You raise a really good point, Dan, which is that there can reach a point where those choices become less meaningful because you are being asked to make too many of them, and it's very difficult to manage and to think about and to hold. On the other end of the spectrum, I suppose you have kind of repetition. We see this in some of the cookie bar work that's been done over the last few years, and certainly have become more prevalent. They are useful as an information tool, but I think the jury is still quite out on the extent to which they provide kind of users with a moment to think about the decisions they're making. And so when we think about this, and when I'm talking to clients and people within Google, it's really about finding the moments where users want the information and giving them the right amount and specificity of it. And we think very carefully about the sort of both ends of the spectrum. On the one hand, you can be a little too simple in it. And on the other, you can reach the point of cognitive overload where the user and the people making the choices, it becomes much harder. And so there's no you did a very good job playing the professor. You certainly asked an unanswerable question, but I think in the end, it's always going to be a needle. And we are taking lots of inputs all the time about where to set that needle. Regulation and lawmaking is certainly one of them. User sentiment and where we think users want to understand that information is another. And just our own beliefs and principles about what we think users should know as they move across and through our services. And I think on all fronts, one other facet of this is consistency. And it's important to ensure that, to your point, as you make your way across site after site after site, app after app after app, having a framework for users to understand what's happening and a consistent understanding of what things are important to call out and to seek specific notice or to seek consent for. And as we've said before, having that be a sort of model for people to work from is, I think, good for everybody. Because it really is a question of setting the needle in a place that makes sense.
I agree with that. I think also it's really part of what we're seeing is moving away from just the privacy policy as being the notice. And the privacy policies get longer, and there's lots of complaints about how complex they are. And as somebody who writes them for a living, I have to say they are long, they are complex, and they continue getting more so because laws require more in the privacy policy, but their very length, like you're saying, Troy, kind of causes that cognitive overload. It's not the right or best way to give notice in many cases. So I do think we're moving more toward, the concept of the just-in-time notices, where the information is being presented at the time the individual's making the choice. And then you have the challenge of striking that right balance, providing enough information to make that informed choice, but doing it at the right time. And we're also seeing, of course, a lot of concern around so-called dark patterns, where the FTC, for instance, recently issued a report. And I think what I've seen is that companies want to make that user experience as simple as possible. People want to get into the website. They don't want to spend a lot of time on the cookie banner. They don't want to spend a lot of time checking this box or that box. But I think when companies try to make that flow smoother by sort of guiding the user, now there's concerns from regulators saying, no, you're actually manipulating the user in their view. But I think that's actually, in my view, be interested in your thoughts for each of you, is going to create more consternation on the part of users when it's a yes or no, and I'm having to make a decision. And I know, even as Dan, you were saying earlier, when I'm going to a website just as a consumer, am I parsing through all of this information myself? Often I'm not, candidly. I'm looking for certain things that matter to me, but I really want to get to where I'm going. And I find the checkboxes annoying too. So it is a hard balance we're looking at here.
And I think that's where privacy policies remain important and useful as a place to have the baseline information about practices and build with layers on top of that, depending on the type of processing or the type of data or the product. So while I certainly share, Chris, in your view that privacy policies can be lengthy, I think they're an important kind of foundational piece of the whole kind of picture.
Right. I think that's a good way to look at it.
Yeah. I think that I'm not a fan of the cookie banners, which seem to proliferate after the GDPR. The idea, and it's also why I'm not a big fan of the affirmative consent model in the EU. I don't think that works either. People don't want to make decisions about privacy all the time. They don't want to. And I go to a website. The last thing I want to do is start looking at the 500 different kinds of cookies that they have. And I don't want those cookies. They're not they're not interesting to me. I just get this out of the way so I can get to the website. And so privacy then becomes kind of an annoyance for a lot of people who just click accept, because if you don't click accept, then you get this other page with every more types of cookies than a Girl Scout cookie menu, and it's overwhelming, and I don't want to take all this time. Just it's not a good time. And you spoke about timing. I'm not in the mood to think about privacy at that point. so I just click accept because then it just disappears. And but now it's a fake consent. It's actually the opposite of, for the regulator and for the law and for the company and for everybody, right? It looks great. Like, hey, user has given affirmative consent. But in fact, it's basically go away is really what my check is. So what's on paper really doesn't match reality. It just looks good for everyone. It makes it pretty. And then ultimately, now, the company has this affirmative consent when really I'm not really giving affirmative consent. I'm just saying go away. And it's annoying. And so, people look at that and say, hey, wait, privacy is basically just being pestered about something that I don't want to be pestered about at this point. And so that's part of the problem. The other part of the problem is that, is there a good time for the privacy to kind of pop up? And I wonder sometimes, is there ever a time? For some users, maybe there is no time, in fact, when they want to think about privacy. They just want to go about their lives. They really don't want to think about it. And you can tell them, hey, think about privacy. But there isn't a time. Should they have to? Should we be forcing them to, or not? And what do we do for a lot of users who might say, look, I really don't want to do this. I don't want to think about this ever. I just don't hurt me.
Yeah, almost the idea that there would be some sorts of uses and disclosures of personal information. Just this is sort of considered fair and reasonable. It's based on legitimate business purposes or so forth. And for those, should we even have any sort of specific notice or specific consent? Instead, focus our efforts on the areas where there's a risk of harm. I mean, here in the US, we've always had more of a focus on trying to identify where there's greater harm to individuals. And so thinking about things like health data, thinking about location data, thinking about those more sensitive types of information and focusing our efforts on protecting those potentially, calling those out more and less on what might be considered, if we can ever agree, sort of on what the general parameters of normal, quote unquote, processing are that don't need to be called out. And, maybe cookies to some degree fall in that category, or many of them do. So maybe we would take a different approach than the GDPR approach, like you're saying.
Yeah. And I'll just start by saying, Dan, that I'll never argue against the proliferation of choice on Girl Scout cookie menus. I think we can all agree that that's a good thing. But in terms of the actual argument that there's some amount of burden or choice being placed on the users that lacks meaning, I think, as I've said, it really depends on the context. And to Chris's point, having a framework that requires, some form of consent or clicks for all types of processing, even down to the more neutral versions that, as you say, Dan, there are real questions potentially about harm. Those are the areas where we really try to focus on other ways to make sure that users are informed to the extent that they want or need to be. And that's where I think there's a lot of really fertile ground for discussion in terms of what are the right things to require or to have standards around in terms of what users are being told about the types of data that's being stored and how it's being processed. And so, as with all of these discussions, it runs a spectrum, and it really comes down to who is defining the harm and what is the goal of any discussion on this. And I think you can often put 10 people in a room and ask them what privacy harm. What is privacy harm and what are the ones that we should go after? And you'd probably find 10 slightly different answers. And so settling on the right place to aim is a very important part of the discussion, whether it's in the design of a product or the drafting of legislation. And we hope that, again, through mechanisms that could bring more consistency to the discussion, there will be more clarity on kind of the places to aim. As it stands, we do work very carefully to kind of both of your points, make sure that there is that baseline trust and make sure that there are certain practices that are by default off limits or by default baked into the experience across different aspects of privacy and security, and building on top of that. So I think when you're managing one product or two or hundreds, it's important to have those kind of baseline understandings of your practices that you build upon, so that ideally people have that kind of feeling of safety and trust when they use the products, and know, to your point, Dan, that if something pops up and asks them to read it and sort of think about it, it's because it means something and it's worth their time to sort of read and think about. And when you look at a lot of companies who have tried to put in place activity controls in different types of settings, the focus, I think, is on that. And certainly we have tried to focus on, the controls that look at location information, that look at search activity and things that people may want to and likely do want to have some form of control over it, and giving it to them in the simplest way possible. But it's a really, really hard thing to get right, for sure.
Yeah, it is really tricky. And one thing I've thought about is the kind of model that other types of consumer protection approaches have. So, look at food safety. I can go to a supermarket and I, want to buy some milk. I don't have to go and research, all the different farms that the milk came from. Is this safe? Are they, what if it's, buyer beware, some milk can kill you, some is fine. And, you have to research it yourself, figure it out. Is this going to be okay? So I have to go and do all this research about each individual brand of milk to try to learn, what is it going to do to me? But I don't have to do that, right? I can buy the milk, and I know that every milk, has a, minimum of safety to it. So it's just something I don't have to worry about, so that's kind of nice. I get into a taxi and I see there's a meter, and the meter tells what fare is a good fare and not, versus you go into a cab, in some places, and you have to negotiate the fare. And how do I know what the right fare is? I don't know. So in a lot of areas that there's a lot less burden on the consumer to research things and to figure it all out. But in privacy, we put so much burden on the consumer. The consumer somehow has to figure all this out. And there's just no way a consumer really can do that in a lot of cases. Not only that they don't want to, but they're not even capable of. But we voice that on them. But maybe it's better to try to figure this out and to say, okay, these are, uses that are not harmful and are okay. And these are ones where, we're going to disallow. That gets, though, to a very tough question that you mentioned, is harm. If we're going to look at that and say we're going to go with harm, one problem is, in the United States, I think courts have really botched harm, and legislatures too. I think they really have not done a good job defining what's harmful in privacy and what's not. And so, I think harm is what you really should look at. It's just, I think it's just done very badly here so far, which is unfortunate, because I don't know what else you look to. I think the other approaches, while they might be simpler, ultimately you can't escape harm, because if you start creating all sorts of restrictions and limitations on privacy for things that don't cause any harm, then people can like, that's silly. Why are you wasting my time? Why are you stopping something that's not hurting me? And it just, so, you're always going to come, I think, always going to come back to harm at the end of the day. You just have to do it right. But doing it right, obviously, is really tricky, because there is not full agreement over what the harms are. So that really presents difficulty. I think it's really hard to have simple rules here because this is really complex, and there is no one size fits all answer.
That's absolutely right. And one of the concerns we've always had in the US, and I think one area we've been thoughtful of is not over-regulating. And so the more you create simple rules that are overbroad, the more we actually may sort of kill the goose that's laid the golden egg in the US, which is all the innovation that we fostered. And I think that's where harm really is important to how we think about this, because in a sense, it comes down to balancing, right? We're trying to say, okay, well, what sorts of uses of data should not be allowed because the business value is outweighed by some sort of impact on the individual. And so I think that is a challenge because, like you're saying, Dan, we haven't really articulated a clear view of what harm is to help companies make that assessment. And I suppose another route would be to try to create, obviously, lots of privacy laws have been coming on the books at the state level. We've got a bill proposed at the federal level to try to address that more through legislation. Or, of course, we have the FTC looking at rulemaking. I think we're looking at this from a lot of different angles in the US. And my concern is, do we end up somewhere that is coherent and that balances these risks appropriately? And I think that's the challenge we're all facing right now.
Well, and a key word you used, Chris, is balancing. And anytime that is involved, there's going to be gray. And I think in particular in privacy, that's the case. If you're going to engage in a balancing, you need to not only look at the harms, but you need to look at the benefits or the gains and the things that somebody got out of the exchange. And the examples for of milk production or cab rides, it's reduced. It can be reduced to a somewhat objective set of standards. And I think everybody would agree that when you drink a glass of milk, it shouldn't make you sick. And if it makes you sick, and it's because the production facility wasn't following safety standards, or there's a line of liability and harm that occurs there. When you take a cab ride, you know how far it was. There's a way to calculate how much the gas and labor cost and the supply and the demand and come up with an answer. I think that it's just much more complicated, obviously, when you're dealing with technology that evolves as fast as it does on the internet, and the vast array of views that people hold about what is or isn't harm when you're using the internet or when you're using any sort of online product. And so into that space does rush balancing and nuanced conversations where you would like to think that there's a robust discussion, and there often is, about the kind of the balancing of the harms and the benefits. But in the absence of clear understanding of the technology and how it's evolving and how it works, I think that, if you look at the jurisprudence and some of the things that you're no doubt thinking of, Dan, a lot of them are maybe born out of that sort of gray and erring on the side of the consumer, and assuming that there must have been some harm here, even if there are arguments to the contrary. And so part of any discussion, whether it's with a product team or a regulator or a lawmaker, is thinking about those balancing and effects and sort of what are you trying to achieve. In the end, I think that it's, as I say, the more sort of standardization and clarity that can be provided through that does foster, I think, potentially room for decisions that are made in a manner that seems more consistent and predictable to people. But that's a really hard place to reach, given all the different equities and viewpoints and ways that people come at this problem.
Yeah, I think really thoughtful insights there. I think one of the tricky points is, kind of where does the law go? And right now we're at a point in privacy law where we're really in a kind of golden age of privacy law development. All these laws around the world and around the United States popping up. This regulation in every corner. There's always something going on. It's very exciting. It's very dynamic, but it's also really messy. And I hear a lot of complaints, hey, this is, how do you comply with all these different standards, and the rules are all different? This becomes a real headache. And I completely agree. I think it is a headache, but I actually think there's some virtues to all this. But there is the federal privacy bill, the ADPA, which is gotten further than most bills in Congress. It's still got a long way to go, and I think the odds are probably against it. But when the bill came out, many people were for it, including a lot of privacy advocates, and folks wondering, like, why aren't you excited about this? Because this is the most strong proposal for a federal privacy law that we've seen yet. But I was ambivalent about it. And I was ambivalent because I was concerned that Congress does not have a good track record keeping its laws up to date. And privacy law really is evolving so rapidly. There's so much in the law now that would not have been in the law even 5 years ago, let alone 10 or 20 years ago. And even now, I think we're a far cry from where the law needs to be. There's still a lot of questions we really haven't figured out very well. I like the GDPR. I think it is the best privacy law out there, but it's still got a lot of flaws. I think its approach, a lot of its approaches don't really work well. It still needs a lot of work too. So I'm just afraid of kind of freezing everything when we don't really know the answer. On the other hand, I do appreciate the fact that there's so much mess out there, and it's really hard. If I were in a company, I would be like, oh my gosh, how do I deal with this? From the consumer perspective, I'm not so sure it's so bad. From the perspective of, certainly from the professor's perspective of, I don't have to comply with this. I can watch them struggle with it. But in a way, I feel like that struggle is a good thing. And that it kind of forces companies to not, a company, if the rules are easy, they'll find a nice mechanical process to put around it, and, they'll do what they need to do. But a lot of time, and you'll get what looks like a really great program, and every I is dotted and T is crossed, but then, some big privacy problems ultimately remain. So in a way, like, the messiness forces companies to not fully be able to do that comfortably. And maybe that's a good thing. Maybe it's good that companies have to constantly be questioning, like, what do we do? Oh my gosh, this is hard. We have to constantly, think ahead and come up with strategies. But that might be a good thing rather than a bad thing, even though it's certainly a big burden. And, I think industry hates uncertainty. So it's not a popular answer I have, but maybe that's not so bad.
It might be the right balance. Because on the one hand, we don't want overly prescriptive laws, but if there's not a lot of prescription in the laws, there has to be process that companies follow internally. And I think that one of the advantages of some of the newer laws, GDPR forward, is having more focus on the operational aspects. The idea of data protection impact assessments for high risk processing, having privacy governance, having people who are responsible. And I think when you have that sort of process, it does, like you're saying, Dan, it makes companies think about privacy on an ongoing basis. And to realize for accountability, they need to be able to show documentation as well. And so going through that process of doing a privacy impact assessment or a DPIA kind of forces some thought around some of these issues when you have to put it down and really think about, okay, what do we identify as the risks? What mitigating measures are we taking? What might this look like to the FTC or the California Attorney General or some other regulator? I think that it gives companies some flexibility in deciding what to do, but still requires a rigor of thought. And I think that the laws can encourage and require that. And that actually, although, like you're saying, it's burdensome to a degree on companies, it allows the law to give a bit more flexibility in a way, because it allows that process to occur as opposed to trying to put one size fits all rules. Love your thoughts on this, Troy.
Yeah, I think it's important to keep in mind that when we talk about all of these things, they carry a certain amount of cost. And if you're required to do these things in a different way in each state or every different region of the world, there are large companies who have the resources to manage that overhead. There are a lot who don't. And I think that it's important to kind of hold both of those things in mind when folks are talking about or thinking about this. And, I think it's not a great outcome, going back to something that Dan said, for a user in Colorado to have a different sort of experience when they traverse the internet than a user in Utah, right? I think that there's some work that needs to be done to make sure that there's a consistency in the experience and in the way that people experience these things. That's really hard to do, but I think it's important, and I think it will be useful across the board. For example, DPIAs or requiring as a matter of law certain types of documentation for certain types of processing could make sense if it's clear what the types are and there's some consistency to that. But if you've got to maintain eventually 30 or 40 different forms of documentation in order to operate a product, that becomes that probably reaches the point where the harms that are trying to be addressed and the things that are trying to be regulated aren't necessarily being appropriately balanced against how much they mean or protect users and the cost of implementing those sorts of things. So I should state plainly that I agree wholeheartedly. It's what we all make our living on, right? That privacy is something that should be top of mind all the time when products are being designed and when things are being rolled out, and that happens by and large these days, I would suspect, as a result of GDPR and other frameworks that have set as a foundation privacy by design and early involvement and thinking about how to develop things in a privacy forward way. Documenting those is certainly a super important part of that. But it can be a little red tapey and crushing if it's not thoughtfully enacted.
Such a good point.
Yeah, I think that definitely makes sense. We don't want 50 different versions of a DPIA. I think that said, we want to make sure though that the DPIA or the privacy impact assessment is good and that it's complete, that it really looks at all dimensions of privacy. Because a lot of times you ask, but what's privacy? Oh well, it's just keeping it confidential. Oh well, it's just put some access controls on it or encrypt the data, and that's privacy. And so I think the DPA is only as good as the conception of privacy underpinning it. And so we really need to think about what, should that look like? And I think more guidance by lawmakers on that would be great. And I think that, we could come up with a consensus on that, a better consensus of what that ultimately looks like. Maybe there's a few differences here and there, but I think that we can at least improve upon that and come up with one that, is a standard that goes above everything. And I think it would be pretty involved, but it's still, something I think we could do. One case I love, but I know that industry has typically not liked it, is an FTC case involving Sears. And the case involved a Sears that installed this program on people's computers, and it acted as spyware. And this was disclosed in the privacy policy. So it was there in the policy. And people didn't opt out of it. They went ahead and installed it. And the FTC said that this is unfair. It's unfair practice because this is buried in a privacy notice that most people aren't really going to read or really pick up the fine print. And therefore, if you're going to use this kind of privacy invasive software, the notice is to be much more conspicuous. And the pushback was, well, now you've taken what's a clear rule, which is, hey, if you disclose it in the privacy notice, that's good enough. And now you've turned it into a mushy rule. You've turned it into something muddier. Right now, it's sort of a standard. Well, the conspicuousness of the notice depends on, proportionately the privacy invasiveness of the particular practice. And so now that rule is a lot, more, malleable, and it depends, and you have to make more of a judgment. And a lot of industry, well, my gosh, that's really hard because we want an easy rule, so we can just check it off. And now we actually have to think about this and weigh, how invasive is the technology and so on. I think this is wonderful. Like, I look at Sears and I think this is exactly the pinnacle of FTC, of what the FTC does. I think it's a great case. I think it's exactly right. And I think that's, but it does introduce, some more cost. It makes it harder to comply because you take in a simple rule and you've made it complex. But my take on it is that that's the kind of thing we want. And I don't think it's overly complex at the end of the day. I think, it's pretty commonsensical. If you're using a very invasive technology, we know people don't read the privacy policies. We know they're not really looking at this. So maybe we do need some more, just-in-time notice, or for something like this that's out of the norm, that's very privacy invasive. Maybe this is where we do want some box to pop up in front of someone's face and say, warning, this is really different. The problem is, if you inundate people with meaningless notices, these cookie notices, it becomes the boy who cried wolf. You get all these notices, people are like, okay, how do I know what really matters and what is just, stupid? And if we're doing that, then it won't work. But if we do have the notices for things that really are, then it might actually, make some difference.
I think that's true. And it's also thinking about specificity of notice. And so I thought, as I recall in the Sears case, that software really, the issue was it was so completely different than what a consumer would expect in that context, that you would feel, and I think sometimes as privacy professionals, we also are attuned to our gut sense. Does it feel right? Like, just having a paragraph in the privacy policy, it's like, wow, would I expect, or would my neighbor, my parent, whoever, expect this? And think, ooh, maybe we need more. And so I think that's an element of it too, that yes, it's not prescriptive. We're not going to say these are exactly the sense, but you think about consumer expectation, and you also think about, again, the specificity of it. It's not just, I agree to that privacy notice. It's having to call out, here's specifically what we're bringing to your attention and what you make your decision on. And that helps to provide more meaningful notice.
Yeah, and I agree. I don't think the facts and the conclusion in Sears are inconsistent with what we were talking about earlier, right? In terms of balancing, to your point, Dan, the type of software that was installed, the way in which users were agreeing to that through a box that had a scroll bar, if I recall, was a big part of the discussion there, and you could click agree without having gone through it all. There's a balancing that needs to occur in any of these decisions that you make and how to inform users. And one thing that's worth calling out, I mean, Sears, if you think about the technology and the modalities that would have been available for informing people at the time that case came down, I don't recall off the top of my head when it was, but I think it was pre-2010, probably, in the 2000s. And so the richness of UIs and kind of modalities that are available now to ensure that information does get in front of people and they have an opportunity to review it before moving on are much richer. So I think it probably pushed things in a direction that caused people to rethink that and think about new ways to achieve the precise thing that we're talking about here, which is ensuring that users are well informed about the choice that they're making. It's an extreme case to be sure, but certainly one that probably was an early harbinger of some of the expectations that there would be about making those weighted decisions about the nature of the processing and the extent to which and how users should be informed.
Yeah, I think that there is going to be this pain as after Sears, where the law should be pushing the state of the art. It should be pushing companies to innovate on privacy and to do things that are hard. Just like I think the law should say to automakers, make vehicles that have less emissions and be aspirational, push them to achieve a goal that is difficult, but it's tough because you are pushing the envelope. You are pushing for things that need to be developed that may not be there. But I think that's the role that the law should be doing because otherwise, I don't think there are enough market incentives to spend time and resources to innovate on privacy, to really think about how to do this better. I don't think consumers really know enough to be able to do this. And that doesn't mean it's not important. And some people, oh, well, people don't really care. I think people do care. I just don't think they're equipped. And I think the market doesn't really reflect that. Just like for security, I mean, there's very little ability for people to pick more secure products versus less secure products. It's not because they don't care about security. It's just they don't really know how to evaluate that. And so they'll evaluate what they do know. They can evaluate price. They can evaluate, how well a product, does, what it's supposed to do. But they really can't evaluate privacy and security very well. So I don't think there's a good market. So that's where regulation, I think, is needed, is to force it to be considered.
Certainly, I think Chris said earlier, having a bar that you are aiming for or trying to meet is important, and regulation, reasonable, consistent regulation can provide that. And we certainly support the concept of a federal regulation that brings some of that consistency. With all of these things, it's like shopping for a house. There's a list of things that you're going to really want, and you're not always going to get them all. And there's just so many different voices and concerns that everybody is considering as part of this broader discussion. And it's a question of finding the right balance to making sure that enough of those boxes are checked in the right way, that it achieves the ultimate ends, which are to create more responsible practices and accountability, which most are accepting of at this point. It's a question of how, and I think a lot of companies, ours included, have hewed very closely since 2018 to GDPR and its standards, and doing everything we can at the moment to prepare for the various state laws that are coming online, while at the same time, hoping that there's a little more consistency brought by a more federal approach. And so, where that all lands, I think you're right. It's sort of up in the air still, in a very, very complicated discussion, obviously. But at the end of the day, I think it's going to come down to the extent to which companies are able to maintain innovation, maintain advancement, maintain good, compelling products without, to Dan's point, giving people more than they ask for or need. Again, back to my old needle I started with, just finding the right place to set that is very important.
Yeah. Your discussion of state laws made me think about how we're all looking ahead to the next year, and then we'll have sale opt-out in California, sharing opt-out. Other states, it will be opting out from targeted advertising. This is the sort of nightmare scenario that companies are worried about. And we're looking at 5 states now. Who knows how many more states. And then when the choices differ, and I remember you mentioned this earlier too, Troy, where versus whether you're in Colorado or California, is that really privacy protective? I mean, if you're really trying to treat people differently based on their state of residence, how does a company even determine that? First of all, how do you honor it? So I agree. I think that most of the companies, I mean, really all the companies that are being vocal about this want to see at least some degree of harmonization where there's some level that we can address it nationwide, as opposed to having to do different things for people in California. But that seems to be a real open issue. It's one of the hardest issues about federal privacy law and has been, for years.
Yeah, and I'm not sure that that law is going to pass. I mean, it's I think now more unlikely than not, than likely. As far as the states, I mean, I think that generally there's California, which I think is the leading law, and I think the law has a lot of flaws because I think it does rely way too much on individual choice. It seems obsessed with data transfer as if that's the only real privacy harm when there's a lot of other issues that it kind of leaves on the table. So it doesn't address a lot. So I feel like it's very incomplete, and it's just obsessed with transfer. But there's all sorts of limitations in it that are not addressed. And I think that when you look at the other states, I think a lot of them, their bills are it's not, there's some variances, but not a lot. They're surprisingly similar. It basically, let's take California, let's kind of water it down a little bit to various degrees, and let's put it out there as a law. So you have it a little bit watered down, and you got Virginia, and then a little bit, and then why don't we totally water it down and make it like a Bud Light for Utah, which that law basically, I don't know really what it does. It's one of the emptiest laws I've seen. So I mean, I think some of these state laws are really not players in the mix. I mean, it's great for the number to say, hey, there's 5 now. But really, I don't think Utah counts. I don't think there's anything that Utah does that's stronger than any of the other laws. So if you're doing business in all the states, I don't think you really need to worry about Utah. But maybe there's something that I'm missing. But I think that for a lot of the states, there isn't. Now, there's always the risk that as more states come on board with something, there will be something that's different from California. I mean, part of me is also hoping. I know industry doesn't want that. I kind of want the laws to differ more. Like, come on with some more stuff. Why don't you do something that California isn't doing and make it even broader and bolder? But so far, that's not what I'm seeing. That still, I get the fact that there's all these different standards, and it becomes really tricky if every state has a slightly different set of definitions for sensitive data. I mean, these are headaches.
Yeah.
But I guess as headaches go, I think I've been surprised at how similar a lot of these laws are, rather than different. I think folks like to cut and paste. Around the world, it's like cut and paste the GDPR, and then in the U.S., it's cut and paste California.
I think that's right. I think that the Virginia, the Colorado, Utah, Connecticut laws all fit more neatly with GDPR. They're not as broad, but they fit within that structure. I think, thinking about notice, one thing I personally find challenging and frankly a little frustrating about CCPA is the need to draft a separate CCPA notice with listing out the categories as enumerated in the CCPA and having these, adding an additional page or two to the privacy notice because you have to, because the requirements are so quirky and state specific. When does that really add to the notice? So I think that there are ways, to your point, the CCPA is by no means a perfect law, and it has its own challenges as well. But it is, the more we have these state specific notice requirements, it just makes the whole situation worse.
It's also just final thought on this, worth remembering that states do currently have and use mechanisms for protecting their consumers. There are numerous multi-state attorney general investigations that occur and ways in which they're able to do that. And so to layer on top of that this additional patchwork of state laws definitely complicates matters and raises the question of what is it trying to achieve that can't already be achieved through existing mechanisms by which states can enforce their own consumer protection laws and through the means available to them now. So yeah, definitely a complex area.
Yeah, states do have their own UDAP laws, Unfair and Deceptive Practices Acts, often called the mini FTC acts that states have, and so they can always leverage those and enforce against unfair and deceptive practices, and some have done so. I mean, it's interesting that there's only a fraction of the states that really seem to have cared. So if you look at the states that kind of have really enforced rigorously on privacy, that really are kind of staking this territory out, it's only a few. But now after California, all these states have jumped in. Now I see the Utah bill not as a state that is like, oh wow, we suddenly are caring about regulating and privacy. My take on that bill is that it was a placeholder, basically, mainly a pro-industry bill to essentially say, we're not really going to do much on privacy here. We're going to be the kind of anti-California. That was my read on it, not the other read. It basically took the place of what a privacy law would be, but it's not really that much of a regulation. It's almost like a statement saying like, we kind of don't want to do much here. But other states might jump in. I just wonder how many will ultimately do that, because historically, states haven't really used their enforcement tools, haven't really done a lot. Only some have. So maybe they'll do more if they pass a law, but historically, I think there's just some states that just don't care at all. So I'm not sure we'll get all 50. I don't know. I mean, we did get all 50 with the breach notification.
Eventually,
But that's easier, I think, too, is that breach notification is very easy for a state to kind of join in. And I think after a while, it started, if you're like the two states that don't have a law, you're kind of almost pressured to come up with something. I'm not sure we're going to see 50 laws. Maybe we'll see 20 laws, but that's if we get that. Most will probably look somewhat similar to California. Most will probably be weaker. Maybe some will have a stronger provision here or there. Remains to be seen whether or not, those create, a long-term headache. Let's say we don't get a federal law. I don't know. When the data breach notification laws were being passed, it was, I thought, I testified at a hearing in Congress, and I thought, oh my gosh, of course there's going to be a federal law. Everybody was saying it would be utterly impossible to comply with 50 state laws. And this is a time we'd even have 50 state laws. We had like 20. And guess what? Where's the call for a federal law here for data breach notification? No one seems to care anymore. I think privacy is different. It's going to be a little harder, but I do wonder, because it was pretty much thought at that time, like, of course there has to be a federal standard. It's impossible, and it's not. And that's one thing I think with privacy that's amazed me as I followed this field for 25 years is a lot of the things you think, and you think, oh my gosh, this is, urgent, amazing, it's going to work this way, don't. And it's like Y2K. Everyone thinks, oh my gosh, this is the big issue, this is the big thing, and then suddenly it's not. So at the federal law, a private right of action is a complete non-starter. There's absolutely no way at all, and there it's in the law, in this new bill. So I do wonder, just a lot of things that you think are big or really important have changed pretty rapidly. So it's humbling how, what we think we know, what we think is going to be hard and easy might be very different in the future.
That is true.
Well, with that, I just want to thank you both so much for joining me and thinking about these issues. There's just, I think, more questions than answers, which for a professor is wonderful. For folks, advising clients and working in companies trying to figure out how to navigate this landscape, I think it's much harder. Because you actually have to do things and advise things, where I can just sit back and think, "Oh, interesting." But I do think you're engaging with these issues in really hard issues without easy answers. So in a very thoughtful way, and I appreciate your very thoughtful answers to some of my unanswerable questions today. So thank you so much, and really enjoyed our discussion.
Great. Thanks
Bye,
for having
everybody.
us.
Thanks.